Now is George Gordon.
Well, greetings again. We're going to take up Lesson 3 today. And Lesson 3 is the Exclusionary Rule, and it's the heart and core of your Fourth and Fifth Amendment rights. The Exclusionary Rule is so important that we do this in two parts, Lesson 3 and Lesson 5. And I want to warn you going in that it may be dull, uninteresting, boring, and routine. But so important is the Exclusionary Rule and the Fourth and Fifth Amendments that we cannot have individual liberty and freedom, nor can we win on the courtroom floor without them. They're the heart and the soul of our Constitution. And as we go through the statements by Supreme Court justices like John Jay, Marshall, Warren Burger, and other eminent justices who have served on the Supreme Court, no matter what your political persuasion, no matter what you may think of them, the one thing that you always want to keep in mind is that the Supreme Court of the United States, insofar as you and I are concerned in our everyday way of life, is the law of the land, whether it's for good or evil. There is no appeal beyond that Supreme Court. And that being the case, I dare you then to go to the Supreme Court or to take your case to the United Nations or to go out and break laws with impunity or ignore those Supreme Court rulings. That's how important those are. So where I start with this lesson with a student is with your Constitution. In this box, in this packet with your tapes, you have this little American Legion Constitution, and this is the book that I use exclusively. The reason I use it exclusively is because whenever I'm talking to students, you can reach in your shirt pocket, pull it out, open it up, and we're on page 21, and you can follow along with me. You don't have to buy them from us. I'm not sitting here selling constitutions and making money off of them. We charge 50 cents a book, I think, for these as they go out of here. If you need to order 20 or 30 of them, we'll send in a little money and we'll send out a batch. Otherwise, just go to your local American Legion, wherever you are, and I think they'll give them to you for a donation. I think that's what we do here is we donate 50 cents a book or something like that for their cause. When we open up our little Constitution booklet here in the, so we'll start here on page 25. You'll notice this is the end of the Constitution proper on page 25. When you turn over to page 26, you start out here with what's called the Bill of Rights. The Bill of Rights, then, aren't rights that are granted, I should say, from the government to us. These rights are inalienable rights that we, the people, have retained to ourselves. And the very word inalienable means you can't take them away. They're not negotiable. You not only can't take them away, I can't give them away. I can only waive rights for a period of time. You cannot give away your inalienable rights forever. It's impossible. The courts have ruled on them. So we start out here with Article 1 and Article 2 and Article 3, and we get down to the famous Fourth Amendment. And if there's ever a piece of constitutional literature that is more misunderstood by the average citizen and little used by the average citizen, it's got to be these two, the Fourth and Fifth Amendments, which as we read through we're going to find are so crucial to our freedom that without them we wouldn't even need a constitution. They're superfluous without these individual inalienable rights. So let's just read along. The Fourth Amendment then to our federal Constitution is that the right of the people to be secure in their persons, houses, papers, and effects. I defy you to come up with 4 words that describe all of your property more succinctly than those 4 words. When you find one, let me know. They are protected against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, boy, don't ever forget those words because they're crucial, supported by oath or affirmation. There has to be an affidavit in support of this, and particularly describing the place to be searched and the persons or things to be seized. It must particularly describe the place to be searched and the person has to be named. No person, in Article 5 now, shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Those are some of the most powerful words, and as we go along, I'm going to show you how to use those words in every felony. In the state of Idaho, there has not been a lawful conviction since 1895, and one of our instructors here this morning told me since 1889. He said, "Gordon, you do err not understanding the law." And I'm not sure about that period from 1889 to 1895, but I can guarantee you this, there haven't been any lawful convictions in the state of Idaho since 1895. Part of it, in the last 18 years, is attributable to these first three lines here of the Fifth Amendment. By adequately using this exclusionary rule and those three lines, I could win. I could literally shoot and kill somebody in a room with 10 witnesses and not be convicted in the state of Idaho with a conviction that would hold up in face of the Supreme Court. And that's fact. Now, I'm not saying that that's right. I'm saying that our government here in Idaho has usurped the chains or the bounds of the Constitution to such an extent that they can no longer function at the common law and cannot convict people without their permission and without their consent. So all I'm doing is saying, well, I'm not going to give you permission to convict me. And that's where that comes down. Let's read on. Line 4 here, except in cases arising in the land or naval forces. So there's what's called an exception. Or in the militia when in actual service in time of war or public danger, and there's where you see a semicolon. So there's your two exceptions to this first issue brought forth here in the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime. Going on, nor shall any person be subject for the same offense to be twice put in danger or jeopardy of life or limb. In my career in 5 years, I've never been able to use the double jeopardy rule. Double jeopardy is very seldom ever practiced by government. In other words, once you're exonerated, you probably won't be tried again. Once in a while, you may use that in your defense. But as a matter of real practical fact in pro se law, you'll probably never use that. Nor shall be compelled in any criminal case to be a witness against himself. Boy, you're going to use that every day of your life for the rest of your life. Nor be deprived of life, liberty, or property without due process of law. This is the due process of law that goes along with the 14th Amendment, which includes equal protection of the law. You're going to use that in every case you argue for the rest of your life. Nor shall private property be taken for public use without just compensation. That's the Eminent Domain clause. In other words, you're going to have to be paid when your government takes your property. But what happens when the police impound your car? Isn't your car your property? That's going to happen to you from time to time. The police are going to impound your car, or they're going to red tag your house when you're building on it or working on it in some way, and attempt to take your property without due process of law and do it without compensation. And you're going to then file a Title 42 suit pursuant to your civil rights and sue. That's the way we handle that. Sound crude? That's right. I'm a very crude man, but I'm a consistent winner. And in order for you to be a consistent winner, you're going to be a belligerent claimant in person. And you're going to learn that when you go into that courtroom, there's only winners and losers. And in order to be a consistent winner, you're going to have to assert yourself in such a way that I'm a free man and I want everybody in here to know it and don't make any mistakes about it. That's the way our founding fathers were. That's why they kicked King George off the continent. Otherwise, this would be the dominion of the United States instead of the United States of America. Well, there you have those two what's called amendments to the Constitution. Now I'm going to go through them, and I want to show you word by word what we're talking about here, and then I'm going to back that up right out of the Supreme Court of the United States. Now I'm going to put a challenge forth to you. I know that by now you've watched Lesson 1 and you're sitting here saying, well, this is his philosophy. I don't know how many times judges and prosecutors, will point their finger at me and say, well, Gordon, this is just your philosophy. I'm challenging you not to believe a word I tell you until you prove it for yourself right out of the U.S. Supreme Court cases or search and seizure law report or some other authoritative book, and I'm not talking about books by men who write about Supreme Court justices. When you look at Miranda, friend, that's the law of the land. When that policeman beats the confession out of you and you sign it, and you challenge that confession in court, it can't be used against you. And when they use it against you, that's reversible error and you will win. You know, I'm a businessman by trade and training and profession. I am not a lawyer. People have asked me, why don't you become a lawyer? I don't want to degrade myself to a level of incompetence and to a level of inefficiency to where I can't function and perform. Lawyers perform a valuable function in our society, and I'm not belittling the legal profession. I'm just telling you that lawyers don't secure rights. You see, lawyers represent clients. Lawyers do not represent rights. Citizens represent rights. Citizens must be those belligerent claimants that claim those rights and do it in person. And that's where this exclusionary rule comes from. But let's take a look now, and I'm going to show you how this Fourth Amendment works. I'm going to explain to you now how these words, what they mean, and how the Supreme Court has interpreted these words. And I use the word interpret loosely because actually they don't interpret the law. The law is the law. They're simply expounding it. To interpret or to interpolate means to change the meaning of, and I don't believe for a moment that the Supreme Court does that. They may have done it a time or two. There may be a justice or two who's guilty of it. But when you look through from Marbury versus Madison to Miranda, you're going to find a coherent chain of cases that all say the same thing pursuant to the Fourth and Fifth Amendment. And if you think there's some changes, take a look at it and let's discuss it, because I don't see that. And those of us that have been studying this Constitution for years, we don't see that. We don't see that in our Supreme Court. All right. Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Take a look at the word shall and not in a dictionary. These are absolute terms. Now notice there's a qualifier called unreasonable search. So the policeman comes out, he grabs you, throws you out of your car, searches your car, finds the marijuana, and he says, well, that's not an unreasonable search. How do you determine what is and is not a reasonable or unreasonable search? Is that something that's left to police discretion? Do 5 million policemen who may or may not understand what the definition of a reasonable search versus an unreasonable search is? Do you think that an MP in the Army, you know, a young fellow goes into the Army, he's 18 years old, he comes out at 25, he's been in there a term or two, and he's made MP and he comes out and he becomes a policeman. Do you think he understands the difference between a reasonable and an unreasonable search? I haven't seen very many like that, and I don't fault the young fellow for that. The people who determine what is a reasonable and unreasonable search at the highest level is called the Supreme Court of the United States. Now write this down because you'll need to look at a number of cases. This is called the Search and Seizure Law Report. This Fourth Amendment is ruled on in every case in America on an individual basis. That's right. Every search in America is subject to review by the highest court in the land in Washington, D.C. I don't care if the policeman searched your car or they broke down your door or it's an OSHA inspector. Searches are subject to individual review by the Supreme Court of the United States. Now, right away, someone's going to say, well, wait a minute, that's impossible. Why, there's thousands of searches and there's only 9 judges and they can't do that. All right, that's true. But the Supreme Court's policy is every time there is a search, there is a procedure and process to qualify the question of whether or not that search in your particular case was a lawful search. What you must do is qualify your case, whether it's a traffic stop, an OSHA investigation, whatever it is, to qualify that case to go to Washington, D.C. I use the euphemism to qualify that to go to Moses. In Old Testament times, Moses had a problem. He was the Supreme Court, so to speak, of these 3 million Israelites out in the desert. You remember the story? And so his father-in-law, Jethro, I believe his name was, came to him and he said, listen, I've got a plan. What we do is we organize judges, and we have a judge over 10, and then we have a judge over 100. That's a judge that decides 10 judges' cases. Then we have a judge over 1,000. That's a judge who decides over the 10 judges who judge over 100. And then we'll have judges over 10,000 and so on. And this is called the appeals process, and we use that to this day. It's just a variation of the appeals process. You know, you got a traffic ticket, you go to traffic court. Don't like the decision, you appeal it to the magistrate's court. Magistrate court decision, you don't like it, take it to the district court. Don't like the district court, take it to the appeals court. Don't like the appeals court, take it to the state Supreme Court. You don't like their decision, then take it to the federal Supreme Court. But the federal Supreme Court will only decide cases that have what's called a major federal question. So when you're out here at the traffic stop, if the officer doesn't create the major federal question, you create the major federal question. And the way you do that is by putting up the exclusionary rule right at the scene of the crime. Remember that? I demand probable cause, a Fourth Amendment warrant, and counsel. Now you've pulled the exclusionary rule curtain down between you and your government. Anything that they seize from that point on is questionable by the Supreme Court. But you've got to make the demand, because failure to make the demand timely waives the right. All right? Now let's go on. An unreasonable search is a search that is made outside the parameters of the Supreme Court's decisions in numerous cases. And today we're going to go through the Carroll case and the Terry case. I'm going to give you some examples. But in the Search and Seizure Law Report is a monthly magazine that comes out every month and is in your law library. And there will be 3 or 4 cases decided by the Supreme Court every month. In fact, this Fourth Amendment is ruled upon more often than any other segment of the Constitution. Probably all the rest of the Constitution combined. That's how important that Fourth Amendment is. Because the Supreme Court recognizes that the cornerstone of privacy is wrapped up in this Fourth Amendment. Now, I want you to read about 100 cases at random over the last 10 years out of the Search and Seizure Law Report. And the reason for doing that is this. At this moment in time, I have to assume you have no search and seizure understanding or background. Questions come up. In a traffic accident, can the police take blood out of an unconscious person's arms? Question. Can the police search the locker of a 16-year-old in a high school? Question. In a routine traffic stop, making a Terry frisk, if the officer takes a package of cigarettes and it has 2 marijuana joints in it, can the marijuana joints be used against the person? Question. In a routine traffic stop, can the officer search the trunk of the car? Question. In a routine traffic stop, can the officer compel the driver to step out of the car and then search under the seat in the immediate proximity of the driver? Question. Can a policeman frisk a man before he arrests him to protect himself? You see, these are questions that come up in everyday garden variety police work. And policemen are out there, remember, dealing not only with citizens claiming constitutional rights, but with some real baddies out there with smoking guns in their hands who have just shot and killed the storekeeper. And, after a guy's just shot and killed a storekeeper in an armed robbery, he's not too apt to hold back shooting a policeman. So you see, the policeman has a right to protect himself. You see, policemen have constitutional rights also. And those constitutional rights have to be protected. What we're telling you then is that everybody's rights have to be protected and that the police have no monopoly on violating people's rights. And that's where that's at. So in order to have logic, reason, and common sense within the framework of the judicial system, somebody has to decide what is and is not an unreasonable search. And there is a body of case law. Let me tell you, it would take 100 programs, maybe 1,000 programs to cover with you reading through these cases, search and seizure. So here's what you do. You have a computer called a brain. Read about 100 cases, and they're like Reader's Digest synopsis. you'll read Schmerber and Zerbst, and you'll read Counsel and Powell versus Alabama and the Carroll case and Boyd and many, many more. Some of these key landmark cases now I'm going to take you through step by step in these two lessons called Exclusionary Rule 1 and Exclusionary Rule 2. And the reason for that is I have already spent, and our staff has spent, thousands upon thousands of hours in research. You don't have to go through all those thousands of hours of research searching out cases. Sometimes, and I did this not long ago, I researched a paper on Social Security, and I looked at 132 cases that the Supreme Court has decided pursuant to the Social Security question since 1935. Only 4 of those cases were appropriate or relevant to rights issues and what the subject matter of the paper was. So here you are reading 128 cases and throwing them away to get the 4 you're looking for. When it comes to defensive strategy in the courtroom, we've already perfected that. We already have the documentation, and that's why you're taking this course. You don't want to go through 5 years of research and study and courtroom strategy and procedure that doesn't work. So what we're going to do is give it to you, the system that does work, and then you take that system and then you build upon that and make it better in the future. But you don't have to go through the failures. And that's the Edison Principle. That's what I use. You know, Edison had about 1,200 patents. It's rumored he never had an original idea. All right? All he did was take the ideas from other people who had been working on a project for a long time, and then he picked up with all of their information and knowledge and then built upon it and perfected it. I'm not a lawyer. I've never been to law school. All I'm doing is picking up on the Supreme Court. I pick up on Bouvier's Law Dictionary and say, well, let me see what it says. I'm a businessman. I'm a corporate executive. I'm a person trained to solve problems, and the problem is, how do you win in the courtroom? Well, let's find out. We have to have cause and effect here. We have to know what it is we're looking for, and that's where your course is coming in here, because we've already tried this in the courtroom, and it either worked or it didn't, and those that didn't work we've discarded, and those that do work we keep. So always go to the Supreme Court. You need these 100 cases then to fill your computer with basic information. You don't have to memorize the cases. You just have to have a general understanding of, when you're out there on the road, can they compel you to take a breathalyzer? Can they compel you to take a urine test? Can they compel you to take blood out of your arm? In some cases, yes, and in some cases, no. Once you've read through some of those cases, you'll find out the basic thrust of the Supreme Court's decisions, and it's all rational, logical, and it's all common sense. Sometimes yes, sometimes no. But never accept this dogma from the newspapers that the Supreme Court is just blindly turning criminals loose on the street. That's poppycock. And it's time that we understood that. Don't go to the Statesman and don't go to the New York Times to find out what Warren Burger means or what he thinks or says. Go to Burger and ask him, and he'll tell you plainly right there in his decisions. You can get it right out of his mouth. Then you can disagree with it. Going on here with this Fourth Amendment now. Unreasonable searches and seizures shall not be violated, and no warrant shall issue. Well, what happens if a judge issues a warrant in violation of these principles? Then what happens? Well, then, whatever evidence was seized by this illegal, unlawful warrant is thrown out as evidence and cannot be used against you in court. That's what that means. Now, it has to be issued, this warrant has to be issued upon probable cause. What does probable cause mean? Probable cause is when an average person in reasonable circumstances, based upon his experiences in life, comes upon a problem. Would that person, based upon reason, logic, and common sense, take this course of action, or suppose that this was probably true, or recognize that, yes, this is more than likely logical? That's what probable cause is talking about. Let's take a case out on the road. The policeman, he watches you go by and he shoots his radar gun on you, and the radar gun says 80. Now, he looks at you and he says, well, no, I think he was going 60. Does he have any probable cause to believe you were speeding if the speed zone was 50? Yeah, his eyeball and his trained observation tells him you're speeding. His radar gun says you're going 80, but you know that could be measuring a billboard or that could be measuring a horse running through the pasture. So he has what's called originally reasonable suspicion. All right? Now he turns on his lights and he runs down the road and he stops you. He walks up to the window and he says, hi there, going a little fast, weren't you? Oh, yeah, I guess I was going a little over the speed limit. His reasonable suspicion has now been expanded to probable cause. And the reason that he has probable cause is that you just told him, yes, I was going a little over the speed limit. The subject isn't how much over the speed limit. He just now knows that you were going over the speed limit and you're both agreed. His visual observation, his mechanical machine, or his radar machine, and your own admission tells him you're speeding. Now we need to find out how fast. Well, I clocked you at 80 on the radar. Oh, I wasn't going 80, I was going 70. Oh, okay. Now what do we have? Well, we have a confession that you were going 70. His radar told him he was going 80. Now, he never made an accusation. He didn't say, sir, you were going 80 miles an hour, and I'm going to write you a ticket for 80. Typically, the fellow says, you know, you were going a little fast, weren't you? Don't they always come up to you and say, listen, you're kind of weaving down the road. Have you been drinking? Well, I had a couple of beers earlier in the evening. Isn't that what the average guy says? Well, now you've got probable cause to believe that the driver is drunk, driving under the influence of alcohol. You see, weaving down the road doesn't mean a thing insofar as law is concerned. Judges and courts don't care about weaving down the road. Weaving down the road isn't against the law. Weaving down the road is a symptom of something that may be against the law. That gives him probable cause to believe that you're driving under the influence. So he stops you. Now you've eliminated probable cause. It goes from reasonable suspicion to probable cause to admission. Remember, 90% now of all of the criminal convictions in the United States come from admissions and confessions. So if you can just learn to shut up, you've got a 90% chance of winning. When the policeman says, have you been drinking? I want to explain to you something here, officer. I don't want to make any statements if I'm in custody. Now, am I in custody? And he'll probably tell you, no, you're not in custody. This is just a routine traffic stop. Oh, I see. Routine traffic stop. Let me ask you this. Am I free to leave? No, you're not free to leave. Well, then if I'm not free to leave, then I'm in custody, pursuant to Miranda versus Arizona. Okay? Now, if you're in custody, the Fifth Amendment then applies. And you have that Fifth Amendment protection. If these rules of law are used by criminals, why shouldn't we, the honest citizens seeking rights, use the same exclusionary rule? Did you think that the exclusionary rule is designed to protect criminals? Let me tell you, nothing can be further from the truth. It's designed to protect the citizens, but the citizens don't know about it and can't use it. The only people, to my knowledge, who use the exclusionary rule are the criminals. Bank robbers and rapists and others. Criminal lawyers use the exclusionary rule. Typically, the policeman goes in, he knocks the door down, he violates this unreasonable search clause of the Fourth Amendment, he seizes marijuana illegally and unlawfully, and the defense lawyer, what's he going to do? He's just hired to protect the man's right. The guy probably is a dealer, and he probably is guilty, and he's probably wicked and evil. But when the policemen violate this person's rights, whether he's guilty of a crime or not, whether he's perpetrating this act or not perpetrating it, he's violating the right. And the duty of the Supreme Court, and as a matter of fact, the duty of every judge, is to rule upon the rights issues. Because you see, this Constitution is the rule book. It's like playing a game of football. And you've got two sides out there, and the referee doesn't sit down there and catch the ball because he's in the open and run into the end zone. The referee sits there like this, and kerplunk, and the ball hits the ground. Incomplete! That's the way a referee rules. And that's the way a judge rules. When a judge has his neutral hat on, and I'm not talking about these executive star chamber chancellors. I'm talking about original jurisdiction judges and appellate court judges. They're referees. They're not there to help you or to hinder you. Just a rule on the rules of the game. Nothing more and nothing less. And let me tell you, friend, when the judge puts his neutral hat on, you can't lose. It's just that simple. Because when you've got this exclusionary rule into play, and we're assuming, of course, you're innocent, because if you're out here robbing stores, then there's a good cause and a good reason to have you arrested and put in jail. Now, I want you to notice something else about this Fourth Amendment warrant that's necessary. It has to be on probable cause supported by oath or affirmation. You can't just go into a judge and say, I want a search warrant to go out here to Joe Smedley's house because I think he's got marijuana in there. I have probable cause to believe that he has marijuana in his house because we caught him down at the Styx Rivers bar last week and he was smoking a joint. So if he was smoking a joint there, he probably has more in his house. No, it has to be supported by oath or affirmation. By who? Somebody that has eyeball contact with this alleged crime, this alleged contraband. So you've got to have a disinterested citizen who comes in your house. I'll explain how this works. Let's say you're having your next-door neighbor comes over. And while your next-door neighbor is sitting in the front room, your wife comes in with a bag of marijuana, and she says, hey, honey, you want to roll a joint? And you say, yeah, sure, let's roll one. You want one, Sam? No, I don't think so. Sam leaves, and he calls the police. He says, my neighbor Gordon over there, he's got marijuana in his house, and he rolled a joint over there, and they have a bag. It's about, I don't know how much is in it, probably 10 pounds. I don't know. Police come out, and they say, did you see this? When did you see it? Oh, I saw it about an hour ago. Now the policeman has reasonable suspicion. He's almost got probable cause, so now what he does is he says, well, will you swear to this by oath or affirmation in a sworn statement? Well, yeah, I'll do that. So now the guy signs an affidavit. He swears that Gordon's got marijuana in his house. And now he takes that down to a magistrate. Now the magistrate, because of the eyewitness sworn statement that there's marijuana in the house, issues the Fourth Amendment warrant. Well, now what are we going to search? The garage? Well, in this case, remember, it's got to go a little bit further than that, particularly describing the place to be searched and the persons or things to be seized. Right? Boy, that covers a lot of ground, doesn't it? Our founding fathers were real concerned about King George knocking on their doors and coming in and pulling these searches and seizures. All right? You have to have a warrant that particularly describes the place to be searched. Well, that's going to be your house. We don't know where in the house, but it was in the living room. And they might go a little further and say, well, it was in the china cabinet in the living room on the top shelf behind the dishes. And the persons, they have to name the person. They've got to name George Gordon and his wife Pat, let's say, or the things to be seized. Now, they've got to name a bag of marijuana. Now, let's suppose you've got an Uzi submachine gun in your basement. Police come in, search your house. They don't find any marijuana. What that really was a bag of Old Bugler. The neighbor thought you were smoking marijuana because you had it in a plastic baggie, and he's sincere. I mean, he's an honest guy. Just done. But in the search of the entire house, the search got to be unreasonable, and they found an Uzi submachine gun. The guy comes up, this policeman, he says, hey, I've got this submachine gun. What are you doing with this, Mac? Can they use that submachine gun in a court? Nobody knew you had that submachine gun. There's a question of whether or not the submachine gun is illegal. Not everyone in this country can have a submachine gun, but on the other hand, there are some citizens who can. I'm one that can have one. I don't need any permit to have a submachine gun. I don't need a permit to have an M60 tank in my backyard. Now, that doesn't mean that everybody can do that, and that doesn't mean that there are not laws and that there are not reasons why there are some persons who cannot or who must have gun permits. I'm not saying to you that gun permits are not lawful and that they're unconstitutional. They're just unlawful and unconstitutional in some cases with some persons, but not in all cases regulated by the police powers to all persons. That's absolutely phony. All right? Notice then in the Fourth Amendment that, and I'll tell you this from experience, I've had 2 or 3 of these Fourth Amendment warrants served on me by OSHA in my business career. Never have I seen a lawful Fourth Amendment warrant. And furthermore, I don't believe that I have the capacity to issue a Fourth Amendment warrant correctly that cannot be successfully challenged. Now, I'm not saying that there isn't any such thing. But when you read those 100 cases in the search and seizure law report, at all of the decisions that have come down on the day-to-day searches that have occurred, and I'm telling you, I'm not going to take the time now, but I'm telling you, there are individual circumstances galore. There's thousands of everyday circumstances that occur in everybody's everyday walk of life that could issue a warrant or could conceivably create a probable cause or reasonable suspicion for a policeman to search. And the Supreme Court has answered literally thousands of cases. And it's too big a subject to talk about without you first reading 100, I would say. I've probably read 1,000, or maybe I've read nearly all of them. I don't know how many there are. In our law library, the search and seizure law reports runs back to 1973, so it's about 10 years long. And there's about 4 or 5 per issue, and there's about 12 issues per month, so that's 60 a year. For 10 years, it would be about 600 cases total would probably be available to you in your law library. Some of them are repetitious. I would say that by the time you've read about 1/6 of those cases. Now, those aren't the entire Supreme Court case now. Remember, those are just the Reader's Digest condensed versions of the case. If you read in Search and Seizure Law Report a case, use this caution. Remember, that's the editor's license. What the editor says about the case may or may not be what the Supreme Court decided in that case. And that's a fact of life, and you need to be aware of it. That, you know, there are some unscrupulous editors out there or some ignorant people who cannot read and write. And I can readily understand why it is that judges, and especially Chief Justice Warren Burger, will not talk to the press. I've been quoted, I think, 6 times in the newspapers, and not once has the press ever gotten the story correct. And I think that judges understand that, and for that reason, they, as a body of professional people, do not talk to the press. Politicians talk to the masses. Politicians talk to the slaves. Politicians talk to the voters, but judges don't. Judges, many of them, for instance, especially at all the Supreme Court levels, are appointed for life. And the reason for doing that is to totally separate them and insulate them from any popular opinion. The Supreme Court justices can sit there and say, I don't care what you peons out there think. Because if we had a popularly elected court, we would have popular democracy. And the thing that preserves our republic is that Supreme Court. Because I don't care what President Reagan thinks about the exclusionary rule. The exclusionary rule comes from a separate and co-equal branch of government called the judiciary. And the judiciary decides what rules it'll run by. Not the Congress, and not the President. And thank God for that, because there's the division or the separation of powers doctrine, and that's what preserves your Fourth Amendment right. You can sit here and say, that court turned that vicious criminal loose. Let's get to a point where the court turned that citizen loose because that citizen understood his constitutional rights. You know, our police are entrapping people at an ever-increasing rate. They need more and more bodies, just like King George did, more and more bodies to tax by using these police powers to collect taxes. And that's a violation of this doctrine of the separation of powers. You can't tax with the police powers. Now, they do it every day, and that's one of my big complaints. My government servants, my officials are not obeying the laws. They are usurping their powers. I've given them. I'm the sovereign. I'm the sovereign. I granted certain limited powers to my servants to use for my benefit, and now my servants have risen up against me and are now using those limited powers against me. And they're using them against you. And that's where you go into the courtroom to seek redress of grievance by a judge who's appointed for life and doesn't care about the government. He's not popularly elected like the mayor or like the police chief or appointed by somebody. He doesn't care. You can just sit there and say, there's an individual right involved here, and that individual right is going to be upheld and it's going to be preserved. The police in the Miranda case were so poorly trained, they went in and beat this guy up and took his confession from him and then used it against him. You can't do that. Well, now, they did to do that, but then when it got to the Supreme Court, they said, okay, if you guys are going to go out here and violate the basic rule of law of our land, the highest law of the land, with impunity, then we're going to reverse the conviction that you got from it. And that's the way that works. What they're telling the police is, why don't you go out there and do your job and quit violating the law yourself? Stop breaking the law, Mr. Policeman. Stop breaking the law, Mr. Detective. Get out there and obey the law and protect this man's rights. And then you can have your conviction, and then it will be upheld by us. And let me tell you, boy, the Supreme Court will uphold, I'll bet you they uphold more convictions than they overturn. Now, that's the observation that I make. I've never really taken a poll to find out, but there's many, many times that people ask the wrong questions, or they'll get in there and the Supreme Court says, like in the Terry case, you know, that Terry case came down and that didn't violate our Fourth Amendment rights. That protected the policeman's ability to save his own life, and I don't disagree with the Terry rule. You may. I don't know if it's good or bad or right or wrong, but once I understand that the Supreme Court in the Terry rule says that a limited frisk is permissible, and I say, okay. Not because I agree with it, but because that's the law. Whether I like it or not isn't relevant. You see? What I'm telling you to do is obey the law. What I'm telling the police to do is the same thing. You people obey the law. And the politician and the tax collector, you IRS agents out there, you obey the law. And here's the law in the Fourth Amendment. And there's a number of tax cases. You know, these IRS agents run out and knock people's doors down, run in and gather up all these records and books and take it into the courtroom and try to get a conviction. Most of the time, when the citizen is faced with this overwhelming pile of documentation here, and then they'll always overcharge you. I just talked to a lady this morning, and she has a little problem. It seems like that the government has charged her son with first-degree murder in an accidental shooting. Well, now, probably the government will come in, you know, like bargain day at Macy's and say, well, if you'll plead guilty to involuntary manslaughter, we'll accept that. And we'll recommend 5 years probation and 6 months in jail. And now this guy's a convicted felon for the rest of his life in an accidental shooting because he's afraid to go into the courtroom and say, wait a minute, fellow citizens out there, this was an accident. Let me tell you how it happened.